You've got a probate estate opened in Michigan, but you don't know how to fully administer the estate, including paying the creditors, settling all the debts, paying all the exemptions, allowances, administrative expenses, and so on. Hi, I'm Darren Findling from Probate Pro, and we're going to walk you through the steps relating to the administration, specifically in that highlighted area in this video slide that includes settling and resolving debt, as well as distributing the assets. If you've got questions relating to other areas of this particular slide, please contact my office. We'll walk you through it, or watch other videos that we've produced that explain all the steps of the probate administration process. Let's get started. At the conclusion, when you've liquidated all the estate assets and you're ready to distribute, we do what's called a summary of administration, also known as a final account. Within this, it is a kind of a recapitulation of everything that has occurred and everything that's about to occur to close out or conclude the administration of the estate. First, we're going to start with the inventory value. That's the inventory that was filed or presented to the probate court that identified what the decedent owned in their name at the time of death. Then any income that has been received would be reflected, and of course any expenses that have been incurred. Then we look at reimbursing for any costs or filing fees. The statute 700.3805A provides that those administrative expenses get reimbursed. Next, lawyer fees, legal fees, as well as administrative expenses that could include fiduciary fees. Imagine the lawyers wrote the laws and the lawyers made sure that they got paid in a probate administration at the top of the prioritization. There's a payment of an inventory fee that is owed to the probate court. It is based on the gross value. There are certain numbers that you're allowed to reduce that value by, including recorded liens or mortgages or encumbrances on the property. That inventory fee is done or calculated through an inventory calculator that many of the courts will provide to you, or on my website, we provide it free of charge to access to calculate the inventory fee. The next step is to reimburse funeral, burial, cremation related services. That's specified under 700.3805 subsection B. These are reasonable expenses, and of course the term reasonable can really be dependent upon who you ask. Some funerals are quite inexpensive, and I've seen some that are really expensive, in which the court found that the amount requested was just simply not reasonable. Flying family members in from out of town, things like that. The next are what we call the homestead allowance. This is specified under 700.340 or 2402. This specific allowance allows for certain homestead-related expenses that inure to the benefit of the surviving spouse and the family. The next one is the family allowance, and this allowance can be quite large to allow the decedent's minor children and spouse to receive money during the administration of the estate and to receive that money in priority of all other related creditors that may be involved in the estate. Now, these specific allowances and the exempt property we're going to speak of in a moment, these particular allowances and exemptions are quantified within the probate statute of EPIC. There's a table, and it's dependent upon the year upon which that individual died. You could use that table to identify how much the allowances and or exemptions are to be provided for the various family members and whether someone qualifies to receive an allowance or exemption. But let's use a classic example. The decedent dies with $50,000 in a bank account, but they owe $1 million to various creditors, to collection entities, visa companies, and so on. A surviving spouse will be able to exempt more money through allowances and exemptions than is in the estate. So the entire 50 after the payment of administrative expenses, attorney fees, the funeral and burial will receive all of it. and none will go to creditors. That's why this understanding of this pecking order, this prioritization that is specified in those statutes that I've got on the screen is really critical to understand how to use the statute to the advantage, even more than just the advantage, but to do it correctly to ensure that everyone is receiving the appropriate distribution. The next item is expenses, and these would include any other expenses that are specified under the statute and any other creditor claims that are appropriately presented to the personal representative and have not been disallowed. Then, when everything is left over, the assets get distributed. Now remember, if there's a will, the will is the instruction of how you're going to distribute the estate. If there's no will, the laws of intestacy will control. And that means that depending on the family tree, the statute dictates who gets what amount. So understanding how that statute plays out is critical to understanding how the estate assets will be distributed. Now, of course, if you're unsure about any of this, and even if you are sure, I strongly encourage you to hire a lawyer. Hire a lawyer that can guide you through this probate process. Probate administration is not simple. It may seem intuitive, many of the steps, but it's not so simple. There's actually quite extensive case law and extensive statutes that have an effect on how you distribute. So hiring a good, competent lawyer will help you through this process. You're welcome to call our office at 877-YOUR-FIRM or visit us at theprobatepro.com.